All right, gentlemen, everybody keep your head up. Stay seated. Don't put your head down. Don't drop your head. Don't lean against the wall. Don't play with your hair. All right, stay where you're at. Tonight we're going to address everybody's charges and their bond. So don't leave the booth. When I call your name, you got to wave your hand because I don't know who you are. And so your lawyer can see who you are. We'll start with Alvin Gates. Let's see, is Ms. Murray here? Yeah, there's Murray. All right, Alvin Gates. Bostic, it's position 1. 23 CP 224-514, 90 days without indictment. As of December the 29th, there's a $5,000 good bond on criminal damage to property, 2nd degree.
Godfrey, 6 cycles. No prior felony convictions of battery and criminal trespass in 2016, the FTA in 2020, nothing further.
All right. Go ahead, Ms. Murray.
Your Honor, Mr. Gates is a lifelong Georgia resident. He does have a good address in Atlanta. He is not a flight risk in any way. The incident alleged is essentially that Mr. Gates was, trespassing at a property that's a gas station. So he's happy to stay away from that store. And the alleged victim in this case, and will certainly not be intimidating any witnesses. He's not a danger to the community and will not commit any felonies if released on bond. He cannot afford any bond, however, so we would be requesting a UJR on this charge.
All right, go ahead, Mr. Malkin.
Good evening, Your Honor.
Good evening.
We would ask for a $3,000 bond. It looks like he may also be held on a probation violation.
All right. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay away from 902 Donald Lee Hollowell Parkway in Atlanta. No further contact with first name Kotha, last name VENKATESHUAR. $3,000 good bond. Best of luck to you, sir. Michael Alexander.
And Your Honor, that concludes my business. May I be excused?
Yes, ma'am. Have a good evening.
Thank you.
All right, we got, 20, position 3, Bostic, 23 CP 215563, 92 days without indictment, $7,500 good bond as of January the 20th. Financial transaction card theft, theft by taking, misdemeanor.
Mr. Alexander, 20 cycles, prior conviction for robbery and another robbery and battery. Open case, Judge Swall, 23 SC 188709, capital CWAC act, assault, theft by taking, kidnapping, false imprisonment, another CWAC charge, nothing further.
All right, go ahead, Ms. Browning.
And Your Honor, actually, that case that was 92 days without indictment was DWOPed. And so this case is actually from January of 2023. So it is over a year old and still unindicted. Mr. Alexander is 24 years old. He was born and raised in the Metro Atlanta area and has been here his entire life. His address that is with on his booking sheet is the correct address where he resides with his mother. But his mother is moving, so he's going to be moving in with his partner, who is pregnant with twins. She is due in August. They also share a 3-year-old. He was working as a sales associate for 2 years for PacSun prior to being taken into custody. He will be looking for work as soon as he is able to do so. He received his GED in 2021. He does have a hold in Clayton, which we believe is a mistake at this point. The probation has been over for quite a while there. So we're hoping that he can be released to his hold and get that taken care of. So at this time, we're asking that bond be reduced to not to exceed $1,000 per charge.
All right, go ahead, Mr. Malkin.
Thank you. We would ask for a $6,000 bond.
All right, no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons, no further contact with Deitra, Deitra, last name Jones. Stay away from in Atlanta, Georgia. $2,000 per count. Best of luck to you, sir.
Thank you, Your Honor. And that concludes my business. May I be excused?
Yes, ma'am. Thank you. Have a good evening.
Thanks, you too.
All right, I got Tasaka Troutman. All right, it's position 8 and 9, position 10 has been DWAP. 23 CP 224492, 91 days without indictment. We got burglary in the second degree, a $20,000 good bond as of December the 28th. 23 CP 493, 91 days without indictment, a $20,000 good bond as of December 28th on burglary in the second degree.
Troutman, 47 cycle prior FTA, battery, family violence, crossing guard lines, misdemeanor possession, 21 obstruction on probation, 1 year confinement, 2 years probation, open misdemeanor for theft by shoplifting, a couple other battery, family violence, at least 3 felony convictions, nothing further.
Go ahead, Mr. Surgeon.
Thank you, Your Honor. Mr. Troutman is a lifelong resident of the state of Georgia. He has family here, including his mother, and he also has his GED. Your Honor, he's currently residentially challenged. We're working on getting him housing. We're also going to be applying for drug court in this matter. We're still waiting to hear back as to the decision for the drug court application. But at this time, Your Honor, he has a $20,000 bond on each case. And at this time, Mr. Troutman cannot afford. I think even a $5 bond would be too much for him. Your Honor, at this time, we're asking for a bond not to exceed $5,000 on each charge for each case as we continue to work with our social services here within our office to try to get Mr. Troutman set up into a better situation when he will be released eventually.
All right. Go ahead, Mr. Malkin.
Thank you. Based on his record and the FTA, we would request a $17,000 bond on each case.
All right. Position 9, no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay away from 515 Ponce de Leon Avenue. If available, you have ankle monitor paid for by the county with a 24-hour curfew. Court, lawyer, medical, employment. As long as you supply the name of your employer, proof of employment schedule, and the exact location you'd be working. $15,000 good bond. Position 9, ending in 4493. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay away. That's Reverie VR bar. You're going to have an ankle monitor paid for by the county if available with a 24-hour curfew. Court, lawyer, medical, employment. As long as you supply the name of your employer, proof of employment schedule, and the exact location you'll be working. $15,000 good bond. Best of luck to you, sir. Let's see, South Annex. No button. Tamarcus Petty. That you, South Annex? That Mr. Petty? All right, we got position 11, 23 CP 222075, 187 days without indictment. No bond as of October the 16th. Cruelty to children in the third, possession of a knife or a firearm during the commission of a felony, entering auto with intent to commit a theft or a felony, ag assault, hijacking a motor vehicle, first degree, cruelty to children in the first degree, and criminal attempt to commit a felony.
Two prior arrests, open cases, 23 CP 215-598 robbery, computer theft, criminal damage to property, disorderly conduct, 24 SC 0005559, entering auto, 2 counts, 24 SC 000691, theft by taking tools, entering auto, theft by receiving, nothing further.
I hope Ms. Safarasi did the hijacking get dismissed and the criminal attempt is the criminal attempt at a hijacking?
Let me double check. Let's pull up the.
I think it may have.
Okay, so at the probable cause, they dismissed the hijacking
Okay, so
and they added the criminal attempt.
okay, so the criminal attempt is criminal attempt to commit a hijacking. Okay, go ahead.
Yeah. And Judge, he also has another case, which I'm not sure why this isn't on here too, because he's no bonded on it. That 23 CP 215-598. Could we hear bond on that tonight too?
I don't know. The state didn't have notice. I don't have the info on that case.
There's a pending bond motion, I believe. Let me check. So I'm just not sure why I wasn't calendared. It's because he's at 187 days with no bond. So he'd be tied up.
What
Oh,
was the
yeah,
charge on that, Ms. Safrazi?
It's on the new case.
Yes.
It's robbery, computer theft, criminal damage. Oh, he
Okay.
has a private. I'm sorry, Judge. I'm just covering tonight. He has a private on that case.
Okay.
So
All right.
let's not interject, actually.
Okay.
Sorry, this is what happens when you cover. All right, so Judge, Mr. Petty is 19 years old. We do have a good address for him in Atlanta where he resides with his mom. A lifelong resident here in Georgia. We do have good contact information for him. He is working on getting his GED. He was working at Wendy's at the time of his arrest, but he can get that job back. He was a grill. They're pretty forgiving. We're asking for a bond not to exceed $20,000 total in this case. He's not going to go out today because he has that other case that I mentioned, Judge. But he's 187 days. We had a prelim back in October, and no movement has been made on his case. And I would ask the state if they've had victim contact
All right.
in this case as well.
Let's see. I'm going to defer to Ms. Jones because even though she emailed me the listing, I can't get into my emails right now.
Yes, I'm here. What position was that?
This is number 11 to Marcus Petty.
Latoya Gibson was the victim, and we were not able to reach out to her. It was a CAD case.
Okay, thank you.
You're welcome.
Appreciate that. Your Honor, we would request on this case a $60,000 bond, 20 on the ag assault, 20 on the entering auto, 15 on the firearm, and 5 on the cruelty, with the condition of ankle monitor, no contact, and a curfew.
Okay, you got a criminal attempt.
Let's see. Attempt. Let's see. I see cruelty.
Two
Possession.
counts of cruelty, one in the third, one in the first. You got criminal attempt to commit a motor vehicle hijacking.
Oh, okay. I apologize. Okay, 20 on that one as well.
All right, let's see. All right, no drugs unless prescribed, no alcohol, no weapons, no replicas of
Oh,
weapons.
okay. Let's see.
No further contact with Latoya Glass Davis. No further contact with your co-defendant, Michael Moore. No further contact with Davion, Dabian Davis. Stay away from. Stay out of East Point altogether, sir. You can have ankle monitor if available, paid for by the county with a 24-hour curfew. Court, lawyer, medical, employment, as long as you supply the name of your employer, proof of employment schedule, and the exact location you're going to be working. Let's see. We got 10,000, 10,000, 20,000, 10,000, 15,000, and 20,000. 10,000, 10,000, 20,000, 10,000, 15,000, 20,000. Best of luck to you, sir. You can lead the booth. All right, let's see. Got Bobby Evans. Nod your head if it's you, sir. Thank you, sir. Bobby Evans, Mr. Cashlin. Ms. Alfrossi, you covering for Mr. Cashlin also?
No, Judge. I don't know who's covering for Mr. Cashlin. Let me find out.
Okay, thank you. All right, be right back with you, sir. I'll be right back with you. Tyrone Gates. Wave your hand if you're Tyrone Gates. Nope, no Tyrone Gates yet. Shemaine Coffey. Nope. What about Jerome Gray? All right, Jerome Gray. We got Jerome Gray. Let's see. Jerome Gray is position 6. All right, this is 23 CP 224472, 91 days without indictment, no bond as of December 28th, abuse, neglect, exploitation of disabled or elderly person, and battery. Pre-trial.
Mr. Gray, 8 cycles, open misdemeanor for simple battery, family violence, prior terroristic threats, conviction, prior act assault, and a prior misdemeanor, simple battery, family violence. Nothing further.
All right, go ahead, Mr. Surgeon.
Thank you, Your Honor. Mr. Gray is 42 years old, a lifelong resident of the state of Georgia. Prior to his arrest, he was employed at Metro PCS as a sales manager there, Your Honor. He does have family in the area, including his grandmother as well as siblings, cousins. He was previously living off of Connolly Drive, which is the incident location, but Mr. Gray has an alternate address he can stay at, also in Atlanta, off of Burroughs Avenue. Your Honor, at this time, Mr. Gray is in a no bond status, but I believe today is his 90th day, and so he is entitled to a bond. Your Honor, we would ask that a bond be instated in this case, not to exceed $10,000 in total.
Mr. Surgeon, he was out on bond in that other misdemeanor battery case with the same victim. He was out on a signature bond through state court, and that the same victim here was the victim there. You want to respond to that in any way?
Your Honor, I am not aware if the state court violation is connected to this this here Superior Court violation, Your Honor, but Mr. Gray is able to stay away and have no contact with the alleged victim in this case. He has no problem complying with those bond orders.
Okay, I mean, it was a bond condition, so go ahead, Mr. Malcolm.
Thank you. Based on him committing this offense while out on bond for another offense with the same victim and everything else we heard from pretrial, the state would request a $100,000 bond on the exploitation of elderly person and $20,000 bond on the battery for a total of $120,000. Of course, no contact, stay away, and an ankle monitor.
So I've read this a couple times. Slapped his 95-year-old grandmother. All right, so he can't go back there at all. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay away, sir. You cannot go back. You were not supposed to be around the victim before. You cannot go back and be around the victim. Stay away from 2892 Connolly Drive in Atlanta, Georgia. No further contact with Brenda Glass or Lourerrel, last name Gray, Gray. No further contact with any of them. You're going to have that ankle monitor paid for by the county if available with a 24-hour curfew, court, lawyer, medical, employment. You have to supply the name of your employer, proof of employment, schedule, and the exact location you'll be working. You're going to have absolutely no contact with them, sir. Must supply an address upon release. 100,000 count 1, 20,000 count 2. Best of luck to you, sir. So they've said that Mr. Cashland's, Ms. Saltarossi said that Mr. Cashland's case needs to be reset. Do you know how far out, Ms. Saltarossi?
Honestly, Judge, probably as soon as possible.
Okay.
Because of the reset reason.
All right. So we can set Bobby Evans. Mr. Evans, you can leave the booth. We have to reset your case. Thank you, sir.
And Judge, you know when that reset would be, just so I can track it and make sure there's an attorney here?
I'm going to try to reset it for April the 9th.
Okay. I'll let
both his cases be reset to April the 9th.
Is it just one case?
He had another case on here as well, Judge.
He has 2 cases on the calendar?
I just saw one on here.
Mr. Langford, he was another one that was on the add-on. It says that he's represented by Mr. Cashland as well.
Oh, do you want that one to reset too?
Yes, Judge, both of them.
All right. Let's see.
Are they both add-ons? Just so I want to email.
No, just one's an add-on.
Both of them were on the add-on calendar, Judge.
Oh, okay. Yeah, both of them.
Okay.
So Damon Langford. No, you ain't going. I don't know what that means, but your case is reset. All right, you can leave the booth. Bobby Evans, Langford, y'all can leave the booth. All right, Daryl. Let's see. We got Daryl Calloway. Not yet. About John Johnson. All right, that's position 16. Sir, we're not going to hear your other case because you're on a bond surrender hearing for that on April the 4th.
Judge, can I please put my request to be heard on it again? I looked at it. It's a pretrial surrender when they served an older warrant. It's not that he reoffended. If you look at the dates, it's not a situation like that. Can we please be heard on both tonight? They're both on the calendar.
He's on the April 4th meeting.
But Judge, that's like next week. He could post a bond within that week.
I don't know. I mean, you saw who put it on there.
I know. I understand, Judge. But I've been in this situation with my clients before too, and you've heard the cases before. And then I've emailed Judge Drake, and she just takes it off the calendar. So it's really not a problem, and it actually saves resources because the jail wouldn't have to produce him over on the 4th. And he's on the calendar tonight, so the state got notice, and we could just resolve both today.
Mr. Malkin?
Well, we'd be asking for, he's not entitled to a bond on the criminal damage anyway, or, well, it's a bond surrender.
But if you look at the date,
so we'd have to set a bond. Yeah, if that's a
the offense of the
he
new
committed
case,
a new offense while he was out on bond.
No.
For that, what it looks like.
That's not the situation. If you look at the date of the offense of the burglary, which is the second case,
Right.
the offense date is October 6, 2023.
I'm looking at the arrest date, January 19th of 24.
But that's
Okay.
not, they served an older warrant when he was out on pretrial. He did not re-offend while being out on pretrial.
I see. Okay.
So he really didn't violate pretrial. So honestly, he's entitled to the original bond he had on that criminal damage, and then we just deal with the burglary. We set a bond on the burglary today.
So he was out on a pretrial release bond and committed the burglary in January.
No, Judge. That's what I'm trying to say, is that the burglary was allegedly committed in October of 2023. They didn't arrest him on it until January of 2024, which generated the new case. They could have served this burglary warrant on him back when he was in custody under the criminal damage case, and they didn't. They served an older warrant. If you look at the incident dates, it tells the story.
Well, once it had that on there, I didn't even look at it anymore. Once it had that.
The incident had started, had been alleged to committed before he was even out on bond on the criminal damage case, the burglary incident. So it's not a situation where, hey, you're out on a pretrial bond and you recommit another crime, allegedly. It's where allegedly you committed 2 crimes before. They served 1 warrant on you. You get out on pretrial, and then they served the 2nd warrant on you later. He didn't reoffend.
Mr. Malkin?
It looks like that's probably correct. What was his bond on the criminal damage? Was it a UJR?
It was a signature bond with pretrial.
Okay. So.
And then when they served the burglary case on him, they no bonded him. He's been no bond for over 90 days.
So he's got no bond on the burglary, and
No, he's got a $7,500 on the burglary as of January 20th.
Oh, okay. But he's no bond on the criminal damage right now because they surrendered pretrial.
Okay. On the booking screen, it still says no bond on the burglary.
Yeah, there's been a delay with
on the e-file.
Oh, okay. So it's not reflecting it. So, all right. So do you want a 7,500 on the criminal damage?
I mean, I would want a signature bond criminal damage because he didn't reoffend. You guys granted him the criminal damage signature bond, and then they served an older case on him. So
Right.
I just penalizing someone who they didn't even violate pretrial. Realistically, he didn't violate pretrial. He didn't.
No, I hear what you're saying, but it also sounds like maybe the court didn't have the full picture when the UJR was set on the criminal damage because he hadn't been arrested yet on the burglary, but it had already been committed. So yeah. So I get what you're saying that, it's not really a proper surrender because it's not a new offense if the surrender is based on the new offense. So, but he probably ought to have some kind of a bond on the criminal damage because
Reed State is very fair. This is something I've done numerous times over with the state and with Judge Manning and with other judges too. If they serve an older warrant on you, you didn't reoffend. Now, if the situation he reoffended, okay, that would be fair to set a bond on both cases like that. But when it's a situation where you do what you're supposed to do, and then the state catches up to serve other warrants on you, it's not fair to take away the bond that you didn't violate. He did not violate the criminal damage signature bond. He didn't do anything wrong. He checked in with pretrial. He did what he was supposed to do, but they served on a warrant on, so they rearrested him. So they just automatically they just take it away. But a little bit about Mr.
Miss, have we heard from Bostic yet?
No, I don't think so, Judge.
Right.
Assuming that's correct, and I guess, Your Honor, if the bond surrender is based on the arrest for the burglary, then I would say Ms. Safrazi is probably correct. And I guess we can just confirm that with pretrial that it's not a bond surrender for a different reason.
Which defendant?
John Johnson, 15 and 16.
Three, 8. Damage to property. Documents. It looks like the bond surrender probably was done because of the new arrest. It's done by Ms. Hardy. It was done because he was rearrested.
On the 24 PI 000471 case, correct?
Yes.
Okay. So yes, Judge, it's what I was saying. It's the trigger of this case is what pretrial surrendered for.
All right, thank you, Bostic. Yeah.
So the offense date on the warrant though says
10/26/23.
no, it says the offense date is 12/2/23.
For the burglary?
On the on the criminal damage. Look at the burglary. Okay, go ahead. Go ahead, Ms. Safrazi. Just make your argument, will you?
So yeah, I mean it's the criminal damage.
I'll look, just make your bond argument. Let me pull it up.
Okay, so for Mr. Johnson, he's 44 years old, lifelong resident here in Georgia. We do have a good address for him in Atlanta, Georgia, and we have good contact information for him. Judge, like I said, with the criminal damage to property, he was already given a UJR bond on it. He did not violate the court's order on that. So I would ask for the UJR to be reinstated for the criminal damage case. And for the burglary, it's in the second degree. It's an alleged business. I would ask for the bond not to exceed $5,000 total so we could try for the bail project. He's been in 91 days,
I'm
Judge.
sorry. I thought you were done, Mr. Alfredson. A bond surrender shouldn't have been done on it since it predated he didn't commit a new offense. Either the person who did it or it should have been announced that it wasn't a new offense and a bond surrender should have been told not to be done at first appearance.
Go ahead, Mr. Malcolm.
All right, thank you. So, yeah, I think legally Ms. Safrazi is correct about the UJR ought to be reinstated, it could be reinstated. And on the burglary in the second, we would just ask for a $7,000 bond on that.
All right, so
$6,000 bond.
we'll reinstate position 15, position 16, no drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay away from 1449 Donnelly Avenue Southwest and all Checkers restaurants. No further contact with Laura Phillips. $6,000 good bond. Best of luck to you, sir.
Thanks, Judge.
Thanks. All right. Janelle Willingham. Mr. Johnson, you can leave the booth. I need Willingham. All right. Position 7, 23 CP 224487. 91 days without indictment. No bond as of December the 28th. Thereby received and stolen property, possession of a knife for a firearm during the commission of a felony, trafficking in illegal drugs, purchase, possession, manufacturing, and distribution of marijuana. Possession of firearm by a convicted felon and drug-related objects. So the alleges 31 grams of methamphetamines and 26 grams of marijuana.
Did you say Willingham or Evans?
Willingham.
Willingham, numerous felonies, that's possession with the intent, 2012 ag assault, open case 23 SC 191110, schedule 2, firearm doing firearm by theft by receiving PI, and the second one, then there's 23 CP 224487, theft by receiving firearm during trafficking, drug-related objects. Nothing further.
All right. Go ahead.
Thank you, Your Honor. Mr. Willingham's 43 years old, a lifelong resident of the state of Georgia. He is a high school graduate, Your Honor. He is also a father, Your Honor, to 5 children. As you are aware, Your Honor, he is here on his 91st day with no bond. And so at this time, Your Honor, we are asking for a bond to be instated in this case here, not to exceed $30,000 in total.
All right. Go ahead, Mr. Malkin.
All right, thank you. Based on what we've heard with his multiple open cases and his record and the same charges now that he has in the open cases, we would request a total bond of $110,000, 20 on the theft by receiving, 20 on the gun during, 40 on the trafficking, 10 on the marijuana, 20 on the gun by felon, and a UJR on the drug-related objects.
All right. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. Stay away from 1000 Piedmont Avenue Northeast. No further contact with Michael Davis. You have ankle monitor if available, paid for by the county with a 24-hour curfew, court, lawyer, medical, employment. As long as you supply the name of your employer, proof of employment schedule, and the exact location you'll be working. He lives in Douglasville?
Yes, Your Honor.
All right, good. They can stay out of Fulton County. The only reason you come back to Fulton County, sir, is court or to see your lawyer. Do not come back to Fulton County for anything other than court and to see your lawyer. Fill up a gas in Douglasville. Don't run out of gas. Don't get out of flat tire. 10,000, 20,000, 20,000, 10,000, 10,000, and UJR jail. That's 10,000, 20,000, 20,000, 10,000, 10,000, UJR jail. Best of luck to you, sir. Jalen Stallworth. All right.
Good afternoon, Your Honor.
Good afternoon. Now, Mr. Ciabucci, you see everybody's been here making me mad, so you're up. You ready?
I'm ready, hopefully not to make you angry.
All right.
Judge,
Disposition 12, 23 CP 224274, 100 days without indictment. No bond as of January the 16th. We got kidnapping, ag assault, possession of firearm during the commission of a felony.
4 prior arrests, open case 23 SC 189779, meth, firearm during, drug-related objects, purchase, possession, manufacturing, which is in judicial hold 1 FTA and 23.
All right, go ahead, Mr. Ciabucci.
Judge number 1, I apologize for my late arrival. I got notice of the hearing at 5:11, so I immediately jumped on.
Okay.
What I would say is that he's been in custody now for over 90 days without having been indicted, so he's entitled to a bond. We'd ask the court to set a reasonable bond. He's lived in Georgia his entire life. He graduated from Creekside High School. He lives with his parents and his 2 siblings at the home. We're asking the court to set a reasonable bond in the amount of $25,000.
All right, go ahead, Mr. Malkin.
Thank you. The state would request a $40,000 bond on the kidnapping, a $60,000 bond on the aggravated assault, and a $20,000 bond on the gun during.
All right. No drugs unless prescribed, no alcohol, no weapons, no replicas of weapons. No further contact with TIMEAUS Hill, HILL. Stay away from 4605 Oakley Lane Southwest. I have an ankle monitor paid for by you, sir, with a 24-hour curfew, court, lawyer, medical, employment. You have to supply the name of your employer, proof of employment schedule, and the exact location you'll be working. We got 40,000, 50,000, and 10,000. 40,000, 50,000, and 10,000. Best of luck to you, sir. Good to see you, Mr. Sarah Booth.
Judge, may I inquire of the court, is an order going to automatically be produced, or do I not need to present one?
We'll do the order. We'll e-file it. So go on e-file Georgia or wherever and associate with the case, and they'll send it to you.
Thank you, Your Honor. Appreciate it.
All right. Thank you. Have a good evening. Good to see you.
Yeah. Bye-bye.